Hi, I'm Christy McCardle, and I'm your legal coach. So put your thinking caps on. You're now going to learn how to start thinking like a lawyer. I'm a practicing attorney and perform community service as a small claims judge. I know what it takes to present a great case. I also understand that going to court can be a scary and overwhelming experience. If you haven't prepared for a hearing before, you won't know where to start. You need a legal coach. That's where I come in. This video is going to help you get ready to present your best case. And I recommend that you watch this video again and again until you feel comfortable. I'm going to walk you through the entire process. Are you ready? Let's go. Your success begins with preparation. It's essential that you spend ample time before the hearing putting everything together that's related to your case. The key to winning is to be better prepared than your opposition. The best case includes a script or outline and an organized collection of documents for evidence. So take the time, get organized, and get ready to win. One key to being prepared is to script out exactly what you want to say to the judge. Begin by writing down the story of your case. Once all the facts are written out, you must now edit your script. Editing your script is simple. After you write it, read it over again and make corrections and deletions as you go. Lastly, read it out loud so that you can hear what it sounds like to an outsider. What should your script never have? Emotion. Don't tell the judge how much you cried or how angry you are every time you think of this case. Judges will think, who cares? As you edit, you should begin to get a feel for what is relevant to the story and what isn't. Trim down your script to the essentials. In court, cut out the extras, cut to the chase, and get to the real point. Points to keep in mind when writing your script: it should not be more than 1 page. Use bullets to create an outline. Bold key words and underline important dates, events, or dollar amounts. If you are the plaintiff, the one suing, your script should answer the question, why are you entitled to this money? Be very clear in explaining why you should win your case. If you are the defendant, the one being sued, explain why the plaintiff should not receive any money. Your script should clearly but briefly explain why you should receive money, or why the plaintiff should not receive money. Being in court is like being on stage. That's frightening for most people, but by rehearsing your lines for your presentation, you'll minimize your anxiety and greatly improve your chance of winning. Start by sitting at a table with all your documents spread out before you and do a dry run of your presentation. Begin with, "Good morning, Your Honor," and then work from your script. After you rehearse, you may need to edit your script. Rehearse your case again until you have it down cold. Also, try to anticipate what the other side is going to say about your version of the facts. Be prepared to disprove the other party's version of events. Anticipating what the other party is going to say is the best way to be completely prepared. Let's review how to write your script. Keep it to 1 page. Use bullets, bold and underline key points. Remember why you should win. Anticipate what the other side is going to say about your argument. And rehearse, rehearse, rehearse. This is the way to start thinking like a lawyer. Organization is the key part to this whole process. The more organized you are, the easier it is to present a great case. Many people come to court with all their papers jumbled up in one folder, and they end up taking the court's time when they search for a single document during the hearing. Begin by preparing 2 folders. One is for you, and the other is for the judge. I recommend buying folders that have 2 hole prongs on the top. You can buy these at your local office supply store. Put a copy of the relevant documents into each of the 2 folders. That includes your written script, written agreement and contracts, receipts, photographs, and emails. To be really prepared, label each document with tabs and write Exhibit A and Exhibit B, etc. Put those on the documents. Labeling documents with tabs makes it easy to refer to specific documents quickly. It also helps the judge see what you're referring to. If you say, "I'm referring to Exhibit A," the judge will be able to go right to it. A word about receipts. If you have lots of receipts, hand write or type a separate document itemizing each purchase. Include the date, a brief description of the purchase, and the amount of the purchase. Handing the judge a pile of receipts is a nightmare. Total the receipts at the bottom of the document and have the originals on hand at the hearing. Photographs as evidence are fantastic. The old saying about a picture being worth 1,000 words is true, but here's a tip. Don't bring in 20 photos. You edited your script, and you need to sort through and edit your photos too. Present only the best 4 or 5 pictures, the ones that make a person say, "Wow, I see your point." Good, sharp close-ups are best. Crop the images if you know how. I like to tape 2 or 3 photos to a piece of 8.5 by 11 paper. I then handwrite or type a brief 1-line explanation of each image for the judge so that he or she knows what they're looking at. If you're bringing in emails, highlight the date of the email and highlight relevant statements in the body of the email that scream, "Kazam!" liable or not liable. In summary, each single piece of evidence in both folders must be compelling to your case. If you have time and the court is relatively close to you, take a drive to the courthouse before your hearing. You'll eliminate the stress of finding parking and the courtroom, and you'll feel more at ease on the day of your hearing. Another tip? Call the small claims clerk to ask when the hearing cases are being heard. You can Google the court for your city to obtain the telephone number of the small claims clerk. Try to sit through an entire hearing to see firsthand how the hearing is handled. You can learn by watching what the parties are doing or not doing to help or hurt their case. Unless you watch a live courtroom trial, small claims hearings are not what you see on television. There is no big drama, the judge doesn't make fun of you, and no one yells or argues. Dress codes have become very casual in recent years, but casual is not always appropriate. When you go to court, dress nicely and conservatively. Cover up tattoos and don't let your junk hang out. How nicely you should dress depends on the city where your hearing is. In Chicago, a suit might be required. If you're in Billings, Montana, nicely pressed Wrangler jeans and a nice shirt might be all you need. But no matter what city you're in, do not chew gum, do not text, and turn your cell phone completely off. If you do this, you'll be thinking like a lawyer. Fashionably late doesn't work in court. Be on time to the hearing or you may miss your case. The bailiff or court clerk will call roll and will give some instruction before the judge comes out. Once the judge arrives, he'll give some basic instructions and then he'll start calling for cases. When your name is called, approach the correct table to be seated. The tables will be labeled plaintiff and defendant. While in the courtroom, be polite, courteous, and quiet. In California, the small claims judge may be a judge pro tem. Judge pro tems, unlike sitting judges, are not full-time judges, but they are experienced attorneys. Both parties have the right to have their case heard by a sitting judge, that is, a full-time judge of the court. If one party requests a sitting judge, you can't object. If an announcement regarding the availability of a sitting judge is made, raise your hand and make your request. Don't be embarrassed to ask for a different judge. This is your right. Some courts offer free mediation at the time of your hearing. Mediation involves both parties telling their story to an impartial mediator. The mediator then attempts to have the parties agree to a settlement. Keep in mind that when a judge hears your case, there is going to be a winner and a loser. In mediation, both parties may come out ahead because there usually is some give and take. When should you mediate a case? If there's a chance that you cause some of the damages, then you should consider mediation. Mediation is a good way to get a feel for the strengths and weaknesses of your case. If you can't reach an agreement in mediation, then your case will go to the judge for a ruling. The plaintiff will present his or her case first. Then the defendant will present his case. After the defendant presents, the plaintiff has one final chance to convince the judge that he or she should win. Why does the plaintiff get to go twice, you ask? Because the plaintiff bears the burden of convincing the judge that he is correct. Remember to work from your script, but don't read verbatim from it or you'll sound unconvincing to the judge. Articulate clearly so the judge can understand what you're saying. If you're having a panic attack and you can't remember your name, then by all means, read from your script, but only then. Take a deep breath, relax, and tell your story. Remember, most convincing cases are concise and to the point. Try not to speak with a lot of emotion. The judge just wants to hear the facts. If you have documents, photos, or other items to show to the judge, never attempt to deliver the materials to the judge yourself. When you want the judge to look at the documents, simply say, "I have documents for you to look at," and look at the bailiff. The bailiff will come to you to get your documents. Conclude your presentation by telling the judge what you would like he or she to do for you. For example, I'm requesting $5,000 for the money I loaned to the defendant, or I would like my $2,000 security deposit back. Try to be articulate and professional. Watch your delivery and your choice of words. Say yes rather than yeah, and always address the judge as Your Honor. Now you're thinking like a lawyer. More often than not, the other side will butt in while you're speaking. Both parties need to be aware of this. Do not interrupt the other party when they're telling their side of the story. Remaining quiet may be the most difficult part of the entire case. To help with this issue, be sure to bring in a notepad of paper and a pen to the hearing. When you feel like speaking, start writing down what you would like to say. When it's your turn to speak, begin with, Your Honor, I would like to clarify some facts, and work off your notes. Then go on with the rest of your case. If the other party does interrupt you while you are speaking, do not engage in an argument or do not try to talk over the other party. Just let them go on talking. Sit quietly and wait for the judge to take control. The judge has two choices when making a decision. He or she may rule on the case right there in the courtroom by stating, I find for the plaintiff in the amount of $5,000. Or the judge may take your case under submission, meaning that you'll receive the judge's decision in the mail in a couple weeks. For California plaintiffs, if you disagree with the judge's decision, the only thing you can do is carry a sign around the courthouse with your message of disagreement. You have no right to appeal in California. That is why you must present your best case. For the defendants, if you disagree with the judge's ruling, you must file an appeal in the required time frame. In California, that's 30 days. So, you now have a set of guidelines to prepare for your hearing. Here's a quick summary. Script out your presentation. Rehearse your script. Make 2 folders, one for you and one for the judge. Find the courtroom location and nearby parking. Be brief and to the point when presenting your case. Do not interrupt the other party, and be polite and presentable. Appearance matters. Preparation is the key to presenting your best case. The more you prepare, the more confident you will become. You can present your best case. If you're feeling nervous or overwhelmed, ask yourself, what's the worst thing that can happen? You're not going to go to jail, and you're not going to end up in the grave. Keep telling yourself, I know this stuff. I watched Christy's video. Before you know it, the hearing is over. If you need to, review this information once again. And don't forget, start thinking like a lawyer.